Alright, so my name is Clinton Ray Howard. I'm an Aboriginal entrepreneur from the Gloocaps First Nations community. I'm the owner of the Gloocaps Treaty Truck House, also known as Gloocaps Finest Herbal Body Care. My story, what brings me here today is I am currently being called a trespasser and being told to told to leave my own property and business of operation at the Gloocaps Landing, where I'm a band share owner and owner of the said Gloocaps lands that the Chief Council are trying to claim and remove me with the BCR and an interlocutory injunction based off the sole fact that we were I breached a verbal agreement that we were in negotiations with over the last 6 months. So again, to reiterate, I've been operating up the Gloocaps Landing for over 6 months since of April of 2024, and as of recently of November, late October, November, I allegedly broke a verbal agreement, and so they served me a BCR, an interlocutory injunction, to have me removed for trespassing on my own lands. That being said, we had court December 3rd for our court hearing, where I was looking to get the court hearing adjourned based off the sole fact that I did not have time to find proper legal aid or a lawyer for any type of representation, as the timeline was too short. And a lot of the lawyers simply could not represent me with the conflict of interest, being partners or any way, shape, or form relation to any band councils. And all the other lawyers don't practice Aboriginal law and wouldn't be able to handle my case. That being said, when I went before the judge and explained all of that and I needed an adjournment, she refused me and told me I would have to represent myself, even though I didn't explain that I am not a lawyer. I have no experience with any courts, initiations or anything of that nature, and I also have a learning disability. She still refused and denied me an adjournment. And then I also explained that I had representatives, agents from the Mi'kmaq Rights Association, such as Chief O'Reilly and other associates, and she purposely denied and refused anyone to represent or speak on my behalf as a witness, even when I had exhibits that were attached to said witnesses. That being said, I was forcefully put on the stand. I had no idea what I was doing. I stated that multiple times. The judge got mad at me and had to stop and basically tell me what to say and push me along the whole procedure, which went over 5 hours. I felt very scared being up on that stage alone, being separated from any representation or guidance from any lawyers when the opposite party had all their lawyers and all their representation. I felt very discriminated against and belittled, and I felt that the judge was being very racist against me and my association, the Mi'kmaq Rights Association, and the people that were willing to represent me. I've never felt that belittled and scared since I was a child, and it was very emotional for me to be up there and try to do that. But I had to stay strong and fight for myself, and so I was put in a position where I had to basically do the best that I could with the knowledge that I had, which was none. And I basically, as far as I'm concerned, there was a lot of malpractice and a lot of illegal things that was done by the lawyers, the chief of council, and the judge herself, that I'm looking to a motion of appeal and to bring up with my Aboriginal treaty and constitutional sovereignty rights as a Mi'kmaq person that I never had the chance to bring up on that court date. And I just want to clarify again that this is a family community business that supports and employs over 20 community members. Half of are my family members, and this whole thing has brought so much of our family and community together. It supports so much people and families in the community. Everyone in the community wants this and supports this. Everyone in the community is very upset about what is happening to not only our community business, but just how the chief of council are handling the whole community in a whole, and how they don't take into consideration any of the community's voices or opinions, or even allow us to even have any votes or create any bylaws with the chief of council, as they somehow incorporated themselves with the entity Gloocaps Ventures and don't, apparently, as they've told me, don't have to include the community in any decisions that are based on the community. So that being said, I'm just trying to get my voice heard and have the story be told so more people are aware of this, and we can hopefully shed the light on this and make a change. As I'm aware, this is not a solo case for just Gloocaps First Nation, that this happens on multiple communities against multiple chief of councils, and the story needs to be told, not just here but on all fronts of how people operate their communities, the chief of council operate their communities. Okay, so as we first started up at the Gloocaps Landing as of April 20th, 2024, we were approached by Michael Peters and Andy Upton up at the Gloocaps Landing, the manager there, and they came to us with verbal offers and agreements that would give me my own parking lot, my own building. I would have the right to exercise my Aboriginal entrepreneurial journeys and dreams of running my own treaty truck house and stuff, but there would be some negotiations with paying certain fees and stuff of that nature, which I was very willing to negotiate. So around June 1st, they were able to construct the parking lot. So as of June, we moved from the Gloocaps Landing to the said parking lot. From there, they said that they would revise a sublease agreement and they would give it to us when they could, because they were very busy and they were still constructing their own developments, such as the gaming room and the artisan shop and the solar farms that they're constructing, and getting ready to bring up some other business developments, such as a tourism center and other things. There's lots of business development done. So I was very on the bottom of the totem pole of the list of important C's for any sublease agreements or buildings. That being said, I was very patient and I continued to operate in my small mobile trailer for 6 months. I think they finally offered us their first sublease agreement around August, sometime mid-August, and it was roughly 50 plus pages, and it had a lot of rules and regulations and fees and stuff in it. Wanted me to pay over 10% of my revenue, my profits and revenue. Wanted me to pay up to $40,000 in rental fees and maintaining my own grounds of the property that they would be subleasing to me, and all that. And so I just asked them if we could change some things, because not only did I believe it was unfair and went against some of my Aboriginal treaty rights with some of the things they were asking me not to do and sell, such as certain products as tobacco. I also noticed that it seemed the sublease agreement was uncompleted, or it was a draft, which I believe Michael McDonald verbally spoke to me and admitted that it was a rough draft and that it was not complete, and that they would be revising and taking out a lot of that stuff. And so I then continued to wait, and I continued to operate in my mobile trailer until I believe it was around October or November, when they sent me a cease and desist letter informing me that I've allegedly breached my verbal agreement, and that they are now serving me a BCR for an interlocutory injunction to remove me from the property, as I am now trespassing, as they deemed I'm no longer allowed to be there. As far as I'm aware, the only thing that I did to breach a verbal agreement is I put a temporary shed, or this temporary small building down for essentially storage and stuff of that nature on blocks. We did not construct, dig, or put anything permanent down. We did not, as far as I'm aware, we did not breach any verbal agreements that we made, that we would sign a sublease agreement that would be attached to a building that they would offer us. As far as I was aware, that was an offer they were willing to give us, but we did not have to accept. I was just willing to wait to see what offer they had to offer us, to see if I was even willing to accept that building. And that being said, it was coming towards almost December, and it's getting to the winter months, so that's why we decided to put a temporary building down just for such storage and stuff of that nature. because of the and I had no intentions of even operating out of that building permanently. The other allegation was that I admitted to not sell tobacco, but as far as I am aware, I never admitted to do that, and I definitely never signed any paperwork saying that I would not do that. So, as far as I'm aware, verbal agreements don't hold up anything in court on a business professional level. But again, I am not a lawyer and I'm not a businessman. I'm a very new Aboriginal business entrepreneur who has a learning disability, who was just being coerced by the band council when I had a meeting with them that told me that these are my rights or not my rights, and that this is what I have to do or what I not have to do. And again, even with the band council, when I tried to have representation of a lawyer or the Mi'kmaq Rights Association to represent me, they denied me that and told me I had to have the meeting myself, and it was me against 5 peers or chief of council members, including the chief, and they also had their own lawyers and the court meeting as well, but I was denied. So again, I just feel discriminated and belittled and attacked on every front, even against my own community and my own chief of council. And yeah, that's about it. So to start from the beginning, which is very confusing, but when I first went up there and I was approached by Michael Peters and Andy Upton and Mike McDonald and all the applicants of the affidavits of the court here and there, they told me that they wanted to support my entrepreneurial business of selling cannabis, but they specifically said that the tobacco was bad and that that's what supports and would affect the community the most. And that's what we were in negotiations with the whole time of the 6 months of the sublease agreement, was where and how I could exercise my treaty rights but not affect my own community, which I would never want to do. I would only want to support my community. That being said, then moving forward, when I allegedly broke my verbal agreement and they began to serve me the BCR and interlocutory injunction, they actually put out a community update, a statement to the whole community in a newsletter, stating that the only reason that they were removing me from the said property, what had nothing to do with trespassing or tobacco, was solely the fact that I was selling unregulated cannabis and that they were doing it for the safety of the community. That being said, when we went to court, again, their original statement was that I was selling unregulated cannabis and that I was trespassing, and they never seemed to mention anything about tobacco. But then once I was on the stand and cross-examining and I was mentioning my treaty rights and how we were still in negotiation with tobacco, selling tobacco and all of this nature, for some reason they came to us and started offering us like deals while we worked this out in court at the next hearing. And that's when they said again that they backtracked and said, we don't care that he's selling unregulated cannabis and that we just want him to have basic insurance on the property, which I already have and in the works of doing, to have better and more insurance under their own discretion and advice and guidance, to protect themselves essentially, because they were the ones that would be liable for any insurance claims, not me, and they are just trying to protect themselves. But that being said, and then yes, they went back and solely said that it's only the tobacco that they're concerned about and that would affect and harm the community. And so if I agree to have insurance on my building and not to exercise my original treaty rights and not be able to sell tobacco, that they would allow me to continue to sell unregulated cannabis in my own community. And they do not seem to care anymore. It's very confusing, but that's essentially what happened, yes.